Good morning. This is Rajeshkumar. Today we are going to discuss about a theory question on exclusion classes. The video content has been made available for informational and educational purpose only. Kindly go through the disclaimer. Let's start with the theory question. We have to explain the extent to which the English law of the contract controls the use of the exclusion classes in contracts entered between two businesses and discuss the difficulties with the law in this area. In analyzing the English law of the contract and its control over the use of the exclusion classes in business to business contracts, the Unfair Contract Terms Act 1977 UCTA plays their central role, especially as it's applicable to contracts between businesses but no longer to consumer contracts after the implementation of Consumer Rights Act 2015. This analysis examines the provisions of UCTA and notable cases. Further, the English law of the contract governs the use of exclusion clauses in business to business contracts through common law principles and statutory regulations. Notably, the Unfair Contracts Terms Act 1977 UCTA. Let's move on to the exclusion clauses. The exclusion clauses defined as terms in a contract that limit or entirely exclude the liability for certain breaches are a common tool in B2B contracts for managing the risk allocation, for example, reducing the liability or avoiding the duplicate insurances. However, UCTA 1977 restricts the enforceability of such classes, particularly where they seek to limit the liability for the death, personal injury due to the negligence, that is section 2.1, or impose the terms considered unreasonable, for example, section 11. The Section 2 of UCTA, for example, outright prohibits the exclusion of a liability for the death or personal injury caused by negligence, which reflects a strong legislative intent to limit exclusion clauses reach in specific scenarios, regardless of the contractual terms agreed upon by the parties. How the common law control the exclusion clauses. Under the common law, the exclusion clauses are subject to judicial scrutiny to determine whether they were incorporated into contract and how they should be interpreted. The leading case of Photo Protection Limited versus Securities Transport Limited in 1980 set out the limits of common law control over the exclusion clauses in B2B contracts. The court first determines whether the exclusion clause was validly incorporated into the contract. This requires a clear communication of the clause before or at the time of the contract formation. For example, Worley versus Marlborough Court Limited in 1949. In the case of Lay Strange versus F. Grugab Limited in 1934, it was held that a party is bound by an exclusion clause if they sign the contract, even if they had not read the clause. The court traditionally interpreted the exclusion clauses narrowly, especially if they were ambiguous. The contra preferendum rule means any ambiguity in the wording of the clause is interpreted against the party relying on it, as explained in Holston versus Travelers Insurance Co. Limited case in 1954. While the common law provides important foundational control, it tends to favor the contractual freedom, especially in the commercial contracts where parties are assumed to have either equal bargaining power. Let's dwell into the case law and of photo protection versus security. This landmark case in 1980 significantly impacted the legal landscape concerning the exclusion clauses in the B2B contract. In this case, Securica exclusion clause sought to absolve it from liability for the losses caused by its employees, including a fire accidentally started by one of its employees that led to the substantial damages. Initially, the Court of Appeal applied the doctrine of fundamental breach to avoid the exclusion clause, but the House of Lords reversed this, holding that the doctrine did not automatically invalidate the exclusion clauses. Instead, Lord Wilberforce emphasized that such clauses in B2B contracts negotiated between the parties of equal bargaining power should be interpreted based on the contract's wording without a judicial intervention that distorts a clear contractual intentions. Let's move on to Unfair Contracts Terms Act and Reasonable Test. The primary statutory mechanism controlling the exclusion clauses in B2B contract is UCTA. It addresses the imbalance in bargaining power and ensure that parties cannot use the exclusion clauses to unfairly limit the liability for the breach of contract, negligence, or other wrongful acts. What are the key provisions in the Unfair Contract Terms Act 1977? Section 2, it excludes or limits the liability for the death or personal injury resulting from negligence, which is automatically void. However, for other losses caused by negligence, exclusion clauses are allowed only if they satisfy the reasonable test. The Section 3 of UCT it governs exclusion clause in standard form contracts or when one party deals on the other party's written standard terms. Under this section, a clause that excludes or the limit the liability for breach of contract is subject to reasonableness test. The Section 6 and Section 7 of UCTA regulates exclusion clauses relating to implied terms under the Sales of Goods Act 1977, uh, Sales Act, sorry, 1979. For example, the implied term of satisfactory quality, the Section 14 of Sales of Goods Act 1979, cannot be excluded unless it is reasonable to do so. Let's move on to a reasonable test. Reasonable test under Section 11 of UCTA is central to determine the enforceability of exclusion clauses. The court considers several factors to assess whether the clause is reasonable, including the strengthening of the bargaining position of the parties, whether the customer received an inducement to accept the clause, whether the customer knew or ought to have known of the clause existence, the availability of insurance to cover the excluded risk. The test emphasizes the fairness and ensures the exclusion clauses are not overly burdensome or unjust to one party. In other words, the heart of the UCTA control over B2B exclusion clause is the reasonable test. For an exclusion clause to be upheld, it must be shown as reasonable at the time the contract was made. It requires the court to evaluate the factors like the relative bargaining power of the parties, the parties' awareness of the exclusion, and whether it was a standard form of contract. In cases like George Mitchell versus Finney Lockseeds Limited, the House of Lords applied the reasonableness test to a limitation clause, ultimately finding it unenforceable due to the disproportionate loss suffered by the buyer compared to the contract limited liability clause. The House of Lords held that the seed supplier exclusion clause, which limited the liability for the defective seeds, was unreasonable because the buyer could not reasonably be expected to bear the risk of defective goods, particularly given the price paid. Further, in St. Albans City and District Council versus International Computers Limited case, in St. Albans City case, the court held that an exclusion clause limiting the liability to £100,000 was unreasonable because the loss incurred by the council amounted to only £1 million, and the supplier had significant resources to cover such losses. What are the difficulties in the law and judicial interpretations? The law surrounding the exclusion clause, especially under UCTA, is not without challenges. The courts often grapple with the balance between enforcing the freedom of contract and protecting against unfair terms. For example, although UCTA imposes a statutory framework, The judicial interpretation can vary, with some decisions scrutinizing the classes stringently under the unreasonable test. In Heulier versus Rambler Motors, the court did not enforce an exclusion clause as it failed to clearly exclude the liability for negligence, applying a strict approach to interpreting the clear terms. Similarly, in Monarch Airlines versus London Luton Airport, the court held that exclusion clause covering the neglect or default was sufficiently clear to cover the negligence, but cases with ambiguous wording can still create considerable uncertainty, with the courts applying the contra preferendum rule to construe ambiguities against the party seeking to rely on the exclusion clause. What is the impact of ambiguities of the reasonable test? The reasonable test, while flexible, is inherently subjective. It depends on the specific facts of each case, which creates uncertainty for business attempting to draft the enforceable exclusion clauses. This unpredictability may lead to increased litigation as parties may feel incentivized to challenge the exclusion clauses in the hope that they will be deemed unreasonable by the courts. What about the balancing freedom of contract with protection? The UCTA represents a shift away from the principle of freedom of contract, particularly in commercial transactions. While the Act protects the parties from unfair classes, it also imposes a limit on the ability of the business to allocate the risk freely. This may be problematic in B2B contracts where the parties are presumed to have similar bargaining power and should be allowed to agree on the terms that reflect their commercial interests. What about the standard forms of contract? In B2B relationship, the standard forms of contracts often favor the party with a greater bargaining power, leading to the inclusion of the exclusion clauses that can be harsh on smaller business. In UCTA control over such classes through the reasonableness test helps, but the test is often viewed as insufficient in addressing the power imbalances that led to the inclusion of the onerous classes in the first place. There are some complexities in the case laws. The body of the case laws interpreting the UCTA and the exclusion class is vast and can be difficult to navigate for commercial entities. While the statutes seek to bring the clarity, its interaction with the common law and the subjective nature of the reasonable test means the business may face uncertainty when drafting the contracts. To conclude, the English law of contract through common law principles and Unfair Contract Terms Act 1977 places significant control on the use of the exclusion clause in business to business contracts. The doctrine ensures that parties cannot unfairly limit their liability in a manner that would lead to an imbalance in their contractual relationship. However, the subjective nature of the reasonable test and the tension between the protecting parties from unfair classes and upholding the principle of the freedom of contract present ongoing difficulties in the application of the law. The English law, through UCTA and the case law, that places significant checks on the exclusion clause in business to business contract, aiming to ensure that the clauses are not excessively restrictive or unreasonable. Nonetheless, the complexities of the UCTA reasonable test and varying the judicial interpretations presents ongoing challenges in achieving the consistent outcomes. The emphasis on the equal bargaining power in photo protection illustrates the law's difference to freely negotiate the terms between the businesses, while also signaling the court's willingness to intervene where the terms lack clarity or fairness. The exclusion clause in B2B contracts are governed by common law rules of incorporation and interpretations, as well as by UCTA provisions, particularly Section 2, Section 3, and Section 11. While UCTA provide significant control over unfair clauses, difficulties remain in its application due to the subjectivity of the unreasonable test. subjectivity of the reasonable test, the protection of the contractual freedom, and the complexities of the case law interpretation. Thank you.